Hello, my name is Krista Hermans, and I am an estate planning attorney. And welcome to Estate Planning Questions and Answers. So, if you are joining me live, please feel free to put your estate planning question in the chat, and I'm going to go through some questions that were sent in to be able to answer those questions as they either come in as you're putting them in chat or that were sent to me from before. Okay, so first question um, is what happens if I don't have a will or trust in place? And this is really a common misconception when it comes to somebody either not having an estate or having the asset they think would be necessary that they would need an estate plan. And so, generally, when somebody passes away and they have assets in their individual name, and so what I mean by this is it's not necessarily that there's joint tenants or with right of survivorship or assets are held jointly. These are assets that are in their individual name. So, it could be a house, it could be a bank account, there could be retirement accounts where there is no beneficiary designation. These are things that would then have to go through probate court. And probate court in California, which is where I'm licensed to practice, is the process that basically oversees the administration of somebody's assets when they pass away. In probate court, generally you would have somebody come forward. And again, is with no will or trust in place. Somebody from the family would generally come forward to petition the court to have the ability to now start gathering their assets. They start paying bills. Creditors are notified. It's published in a newspaper. These are all things that um, go through this probate court process. Generally, in probate in California, it can take anywhere from 1 to 2 years, and that is uncontested. People are not fighting. It's just how long the process actually takes. During this time, assets are gathered. They might be sold. All this money is brought together. Bills are paid, and at the end, the person who has the what we would call letters, right? The person who's been appointed by the court would then basically give an accounting to the court, say, here's what we found, here's what needs to be distributed, here's what bills were paid. And then once they get court approval, they then can distribute those assets pursuant to that court order. And so a lot of times this happens, and people don't really understand the need to have a will or trust in place. And they just think that, potentially because they don't have enough in assets that it's just going to avoid it. And that's not necessarily true. And so one of the things, once people really understand what probate court is they want to understand how to avoid it. Okay, so if you're just joining us and you have any estate planning questions, I am taking those questions now and answering them. Please put them in the chat, and I will continue to answer the questions that have come in. So, next question that I have is what is the difference between a will and a trust? So, a will is a legal document where you basically tell the court, upon your passing, here's how I want my assets distributed, and here's who I want to be guardians of my children if I have minor children. So this is going to be a document that is the only job of this document is to tell the court how you want your assets distributed. And then that probate court process that I just talked about is done pursuant to the terms of that will. A trust, on the other hand, is different than a will. Okay. A trust is basically just an agreement. And it is an agreement between what we call a grantor, the person who creates the trust, and a trustee, the person who agrees to hold legal title to all of the assets in your trust. Um, and the trustee will follow the instructions in your trust for the benefit of your beneficiaries. So while you are alive and you have a trust, also known as a revocable living trust or a living trust or an RLT or just a trust, all the same terms. The person, that trustee, will then Follow the instructions in your trust if you were to either get sick, right, become incapacitated, or if you were to pass away. They would then follow those terms and distribute according to your wishes to your beneficiaries. Now, what people don't understand when it comes to trusts is that when you have a revocable living trust, when you create it, you are all three of those roles, right? You are the grantor creating the trust. You are the trustee, meaning you are in charge of the assets in your trust, and you are also the beneficiary of the assets in your trust. So you're not losing any control when you have a revocable living trust and you put your assets in your trust. You can move them around, you can sell your house, you can buy a new house, you can do anything you want with those assets because it is your trust, right? It basically just comes into play that if you were to become sick, somebody can now step into the shoes, that trustee or successor trustee or executor, to be able to assist you, right? Rather than having to go through probate. Generally, when somebody has a trust, if that trust is funded with their assets, their house is in the name of it, their bank accounts are in the name of it, maybe they have beneficiaries pointing at it, these are all things that are then going to avoid having to go through probate. Okay? So that is the difference between a will and a trust. A trust um, would avoid probate court, and a will basically would guarantee it. It's telling the court how to distribute the assets. Okay, if you are just joining us for this estate planning questions and answers, please feel free to put your questions or comments in the chat. And I'm going to go to the next question here. Okay. How can I make sure my minor children are cared for if something happens to me? This is a great question, and one that is so important when it comes to thinking about estate planning. A lot of times parents have no idea, especially when it comes to young kids. They have young kids, they have no idea how to get started, no idea how to put those plans in place to have those protections. And so by doing what we call a guardian nomination, this is where the parents would then identify if something were to happen to them, who would they want? Were they nominating to be guardians for those minor children? In California, minor children are under the age of 18. And so it's basically you saying, if something happened to me and the parent of the other child, this is who I would want to be able to take care of my children. The problem with not having a guardian nomination is that if something happened to you, the court would have no idea who you would actually want in this role. And so by completing a guardian nomination, it allows you to tell the court, these are my wishes. This is who I would want in this role if something were to happen to me. Okay. Okay. Next question I have here. What is a healthcare directive? So a healthcare directive is in California we refer to it as an advanced healthcare directive. And what this allows you to do is it allows you to say, if I were unable to make these decisions for myself, here's who I would want to be able to make medical decisions on my behalf. I would want to be able to have I would want cremation, or I would want burial, or I would want to do some type of organ donation for transplant purposes, or none at all. I would want to be kept on prolonged life support with extreme measures or taken off, right? These are all really important decisions that if you didn't have the mental capacity at the time that there was some kind of accident or you were sick, your healthcare directive would allow you to be able to say, these are the things that I would want. Okay, while also being able to identify who those people are that are going to make those decisions for you, or be able to talk to doctors, get medical records, find out what was going on. Okay, another question that came in is, what is the difference between a living will and a will? And there's a lot of misconception when this comes in, um, when it's related to an advanced healthcare directive. So a living will is often referred to as an advanced healthcare directive, or that healthcare directive, whereas a will is a document that is completed so that when somebody passes away, it tells the probate court how they want their assets distributed. So, two completely different subjects when it comes to medical decisions and then decisions regarding your assets, right? So, a will is the one that goes through probate court. A living will or a healthcare directive, they are the same thing, is when it's related to your healthcare decisions. Okay, let's take one final question here. Um, should I include digital assets and online accounts in my estate plan? So it's really important that when you have an estate plan, right, a comprehensive estate plan, that all of the information is included in that estate plan so that if something happens to you, your beneficiaries, your important people in your life, your trustees, your agents, those people would know what assets you actually have and where to find them. So if you have digital assets that aren't documented somewhere, how are they going to know about them? So it's important to make sure that there's references, whether it's statements, some kind of notes, or something that allows them to be able to know where to find those documents. Another thing when it comes to digital assets, people don't generally consider, there are, besides like Bitcoin and things like that, your Apple account, your Google account, all of these things that have pictures, videos, memories, and things, access to those. A lot of these digital assets now have online the ability online to go in and put your agent after your passing, like who has access to be able to get these photos, videos, emails, passwords, things like that. And so it's really important with any of these platforms that you look into what are the capabilities of me being able to either identify somebody or be able to share this information with my important people so that if something happened to me, they would know where to find access to it. Okay, thank you so much for joining me for today's Q&A, and I look forward to seeing you again next week. Please submit any questions that you have, and I will try to get to those first. But again, I look forward to seeing you live, and make sure to sign up for our upcoming estate planning webinar that we have happening in the beginning of February. If you need more information, just feel free to reach out to us and we will get that to you. Thank you so much. Have a wonderful day.